A major embarrassment for the UPA government again. The Supreme Court today ruling that the decision on whether a private citizen has permission to prosecute a public servant must be taken within 4 months. The ruling coming after the court heard Janata Party leader Subramanian Swamy's petition alleging delay by the Prime Minister's office in giving permission to prosecute former Telecom Minister A. Raja in the 2G scam. Chief Legal Correspondent Ashok Bagaria now reports.
Respite for the Prime Minister Manmohan Singh, but a reprimand for his office. The Supreme Court gave him a clean chit on the question of delay in sanctioning prosecution of former Telecom Minister A. Raja. Pronouncing judgment on Dr. Subramanian Swamy's plea that levelled allegations against the Prime Minister for delaying sanction to prosecute Raja, a two-judge bench of Supreme Court blamed officials in the Prime Minister's office and Law Ministry for not giving right advice to the Prime Minister. The court said, by the very nature of the office held by the Prime Minister, he is not expected to personally look into minute details of each and every case placed before him, and he has to depend on his advisors and officers. Unfortunately, those expected to give proper advice to Prime Minister failed to do so.
What the Supreme Court has done is tied their hands to such a point that they cannot delay on corruption cases.
The court also laid down guidelines to ensure that such delays do not recur in the future. The court said it will be mandatory to decide on sanction for prosecution of public servants within 4 months. If the sanction is not given, then it will be deemed to have been given. The Prime Minister's office said, "We welcome the fact that both the learned judges have completely vindicated the Prime Minister while appreciating the onerous duties of his office."
I think to the extent that the court has explained the legal position and has laid down guidelines, that is a welcome decision.
The focus now shifts from the Prime Minister to the Home Minister P. Chidambaram. In the next few days, the Supreme Court will pronounce its verdict whether Mr. Chidambaram can be made an accused in the 2G case for his alleged lapses. In New Delhi, Ashok Bagaria.
Okay, let's turn to that big story that's been breaking this morning. The Supreme Court saying very clearly that the 2G order, in a 2G order, saying a 4-month time limit must be there for the prosecution of public servants. It can be no more than that. Let's raise the big question. Is the 2G order of the Supreme Court an embarrassment for the centre? Is the 2G order of the Supreme Court an embarrassment for the centre? Joining us on our face-off, Subramanian Swamy, Janata Party President, who is a petitioner in the case, and Manu Singhvi, MP and Congress spokesperson. Dr. Singhvi, for 16 months, the Prime Minister's office did not take a decision on the sanction of prosecution of former Telecom Minister A. Raja in the 2G scam. Should not the Supreme Court verdict allowing the sanction for prosecution of public servants now within 4 months be seen to that extent as an indictment or an embarrassment again for the Prime Minister's office?
Well, if it's obviously a very sad and sorry past that any judgment which accepts a legal point to some extent and does not accept another legal point is described as a slap in the face or an indictment. That's a sorry state of affairs. Yes, Mr. Subramanian Swamy has succeeded, A, in establishing locus, and B, in saying that you must decide henceforth sanctions within 4 months. But let me tell you one very important point, Rajdeep. Since independence till today for 60 years, there is no requirement of time limit for sanction. It is we, and happily I can say that my Lokpal report in the preface itself proclaimed that for the first time in 60 years, we have abolished all sanctions. Section 19, Section 6A and Section 197, all sanctions abolished. We passed that bill based on our report in the Lok Sabha. You have to do some soul searching and ask the BJP. Here we have passed the law abolishing sanctions. The Supreme Court in a sense has affirmed that by saying sanctions may almost be declared ultra vires, but we are not doing so.
Dr. Abhishek Manu Singhvi
has done nothing about it.
Dr. Abhishek Manu Singhvi, complaints are pending against 147 officers in 71 corruption cases. As I said, it took 16 months for the PMO to take a decision on the sanction of the prosecution of A. Raja in the 2G scam. Do you accept that whoever is the government of the day has delayed in the past on granting prosecution for sanction? That's one of the reasons why corruption cases in this country do not lead to a logical conclusion.
Okay, Rajdeep, let me give you a straight answer. It is just like the presidential pardon or the proceedings for considering a pardon. They take varying times because no time limit is fixed. Now, because Mr. Swamy never filed a complaint like this during BJP time, so he did not have those examples. But there are innumerable examples of each and every government, including BJP government, sitting on sanctions for months on end. That's a fact of life for the simple reason that there was no time limit prescribed.
Okay, so
now, please understand, I repeat, we have abolished sanctions altogether. We have passed the law in Lok Sabha. The BJP has opposed it. They are the ones who do not want sanctions to go. That's the real point.
Dr. Swamy, Dr. Swamy, respond, because Abhishek Manu Singhvi is suggesting that the Congress has, has always been in favor of expeditiously granting sanction. The Raja case is there, other complaints are there. Is it fair to single out the Congress, or are all governments responsible for dealing when it comes to sanction?
Well, this is hardly a time where we could compare governments and their performance record.
Yes.
What is important is that we must know that there is a Vineet Narayan case of 1996 which very clearly said that you should not take more than 3 months. Then there was a CVC order of 2004 where the CVC has very clearly said that no sanction should take more than 3 months. And the Congress, having been caught on it, later on in the court took the stand that we didn't know about it. But they also didn't follow the other rules of sanction which are very well established in a number of case laws, that the material that is presented to the sanctioning authority, in this case the Prime Minister, he has to decide whether to give or not on the basis of that material alone. In my case, the Prime Minister sent my materials to Raja to ask him for his opinion. And then he sent it to, said that the CBI is considering it. Even after 16 months, he did not decide. So therefore, the Congress party found every way to delay the matter, and to say there were no guidelines is a travesty of the truth.
But Dr. Swamy, in the past you have defended the Prime Minister on the 2G issue. You've said that Dr. Manmohan Singh is not to blame. Do you believe this delay in granting sanction to prosecute Mr. Raja was Manmohan Singh's fault? Would you put the blame at the Prime Minister's office's door today?
No, not at all. Not on the Prime Minister, because he clearly, from what I know, is quite ignorant of the law. He relied on the law ministry, he relied on his officials, he relied on Kapil Sibal. They all gave him wrong advice. Kapil Sibal had come on TV, said, who's Swamy to write to the Prime Minister directly? He is nobody. Why should the Prime Minister take notice of his complaint? Then Salman Khushi said, why don't he go to the police and file an FIR and then come? All this has been shot down by today's Supreme Court. I think if it's anything is a great embarrassment today, it is for Mr. Sibal, Khurshid and Mr. Singhvi, all these so-called lawyers who are arguing bad briefs and giving wrong advice.
Dr. Singhvi, after today's Supreme Court verdict, will the government bring an amendment to the Prevention of Corruption Act allowing sanction of prosecution within 4 months? Is that a logical fallout now? Does the government concede perhaps that its legal interpretation was wrong, as Dr. Swamy is suggesting?
Just give me a couple of minutes, Rajdeep, to just clarify this confusion. I repeat, Mr. Swamy has won only 2 points. One, that he has locus. Good luck to him. 2, that sanction must be given in reasonable time, 4 months. Number 3, since there was never any time limit for sanctions, different cases in different governments took different time periods. 16 months, there must be cases which have taken 4 years, 5 years. Number 4, yes, from now on, even without an amendment, since there is nothing contrary in the Prevention of Corruption Act, to the contrary, giving any time limit, even without an amendment, the government is bound to give sanctions in 4 months. And number 5 is the most important. Most important is, had we got our way and had the BJP not been duplicitous and hypocritical, you would have no sanction from December 2011 onwards, when the Lok Sabha passed the law, but the Rajya Sabha was not allowed to pass because of obstructive tactics by the BJP in giving 200 amendments. Now therefore, with our bill in Lok Sabha, no sanction for the first time in 60 years is required for corruption offences falling under the Lokpal ambit.
Do you concede
Section 19, Section 6A and Section 197? Three sanctions would go.
Do you concede though that in the 2G case the government delayed on granting sanction? Will you concede that today based on what the Supreme Court has said?
No, I will not. No, I will not, Rajdeep, because that's the problem.
Okay.
Delay presupposes a benchmark. When you use the word delay, it means it is X days delayed from a benchmark.
The benchmark has been set as 4 months, you took 16 months. The benchmark has been set at 4 months, you took 16 months.
Now.
Okay, it's being set retrospectively.
That's been set now.
Okay.
No, 1 minute.
No,
any benchmark is set now.
Yeah, Dr. Swamy, you want to respond?
Was not set in when Dr. considering it.
Dr. Swamy, please respond.
No. The Vineet Narayan case is very clear. They have Justice Verma has very clearly said that it has to be 3 months. The CVC of their government, during the tenure of the UPA government, brought out a circular which is on their website saying that you should not take more than 3 months. So where is the question? Now they can't they of course found an excuse. They are saying this doesn't apply to ministers. That is ridiculous. That's what the court has said today. It applies to everybody, and it obviously applies to everybody.
And you believe that the sanction now that today's Supreme Court order empowers the CBI now to prosecute the corrupt much faster. Dr. Swamy, you believe that today's order?
Yes, not only that, today the Supreme Court has empowered a citizen to go and ask for an inquiry without the sanction.
Right.
This is another argument Mr. Singhvi and his ilk in the Congress party have been arguing in court, that you can't ask for an inquiry unless you go and register an FIR, and you can't register an FIR without a sanction. This is the kind of logic they were giving. Today the Supreme Court has empowered the citizen. You don't need sanction to go and ask for an inquiry. Right. That's the most important thing that has happened in fact. Second, if they are seriously interested, they should issue an ordinance today implementing Dr. Ganguly's observation that Section 19 will be amended, that if in 4 months you do not get it, then it will be deemed to be sanctioned and the sanction will be assumed to have been given.
Dr. Singhvi, respond as a final word to that. Do you believe that today's Supreme Court order will force you to bring either through an ordinance, an amendment to the Prevention of Corruption Act? Is that necessary now to allow this time limit of 4 months to be set for the prosecution of officials and ministers?
First, Rajdeep, the very fact that Mr. Swamy, although not trying to admit it, is compelled to admit repeatedly that the Supreme Court has today for the first time, I repeat, for the first time held that a time limit for sanction applies to ministerial prosecutions. It shows that nobody could have judged a delay at that time and there was no time limit. Yes, henceforth and prospectively from today, you will have to follow the time limit, even without an amendment.
And that is an embarrassment.
Secondly, as far as
that it required a Supreme Court, that it required the Supreme Court to tell you that in 4 months, it's not an embarrassment.
If the Supreme Court decides the law for the first time, it is a judgment contrary to the argument made by the government of India.
Okay.
It doesn't mean it's an embarrassment or an indictment or it's a slap in the face, the three phrases I find the media gung-ho about.
Okay,
it is, yes. It held prospectively.
Okay, Dr. Swamy, in conclusion, the Supreme Court has held if the sanction is not given within 4 months, then it is deemed to have been granted. Does not this verdict pose a danger of falsely implementing government officers in frivolous cases? Is there not a danger of that also happening? That's the flip side of the argument.
No, what do you mean? You can't decide in 4 months? I'm surprised. It's because it doesn't require more than a week to decide whether prima facie case has been made out or not.
Okay.
You don't need even 4 months. But 4 months is a lot of time. Nobody will be affected by that.
Okay. And you believe as a result, corruption cases will be speeded up. That's your hope now. That in the future,
absolutely,
no government can sit on files.
That's right, and now we can also go to court and ask for inquiry where we have got a prima facie case.
Okay, Dr. Subramanian Swamy, Abhishek Manu Singhvi on our big story today. Thanks very much for joining us on our Face Off. Thanks very much, Abhishek Manu Singhvi and Dr. Subramanian Swamy.